So, good afternoon, everybody. My name is Andrew Symms. I'm the head of construction at Al Tamimi, and welcome to this webinar in relation to various aspects of construction law as they relate to Kuwait. So we'll be speaking for approximately sort of 40 minutes or so, but first of all, I'd just like to hand over to my partner and head of litigation in our Kuwait office, Mr. Omar. Omar.
Thank you, Andrew. Thank you, Andrew. Hi, everyone. This is Omar Qahtani. I am head of litigation for Kuwait office. I'm excited today to present our office and to you regarding the construction matter. And we handled many matters in Kuwait and the field and the project in the field as many of our clients interesting for construction matter we handled. So today we are ready to represent all ideas or related matter to construction. So thank you, Andrew.
Thanks, Omar. So if we could have the next slide, please. Just to go through what it is that we're anticipating that we'll be talking about. The purpose really is to compare and contrast between the position that is typically addressed within contract documents in the Middle East, which is very much in English, but facing common law issues. But then how would that be interpreted in a civil law context, and specifically in relation to Kuwait law today? So we're going to touch on some themes in relation to bonds, some themes in relation to liquidated damages, and some themes in relation to limitations and liability. And at the end, we will have a short summary of the role of arbitration in these sorts of issues, particularly in relation to calling of bonds, by our partner and head of arbitration, Tom Snider, based in Dubai. So next slide, please. I'll go on to the question of bonds. So the idea is that I'll sort of give a little bit of a summary of the law as it relates to bonds as they sort of grew up in an international construction context in common law, and then Khaled, my colleague in Kuwait, will touch on the Kuwaiti aspects. So next slide, please. So what we have is this concept of bonds. I mean, bonds are used as a means of security over a number of different aspects of construction projects. Whether that's advance payment bonds or bid bonds or tender bonds. But I suppose we're really looking at the issue relating to performance bonds, which are typically 10% of a contract value. And they are there usually to secure the contractor's obligations under the contract and are often there for quite a considerable period of time, some of which are automatically renewed. And are there until either a stage, depends what you want to call it, but it's either the sort of taking over or until final acceptance, which is when which may be a good number of years after taking over has taken place. So these things are acquired usually from a bank and cost a lot of money and can cost more as the longer that they are in place. They are usually on demand. That's a trend that has moved in the opposite direction, certainly in some of the common law countries where they are now more often conditional, but certainly in the GCC and Kuwait in particular, they are on demand. And that's really one of the themes that we're talking about today, which is really, if they are on demand, what is the role that the bank plays and what can somebody who has issued a bond do in order to stop a call insofar as it's felt that the call would be unjustified. And the usual way in which it's done, and it's the same in the common law jurisdictions as it is in the GCC and in Kuwait, is for there to be an application to a court for the purposes of some form of injunctive relief, which is basically an order from the court preventing the bank from paying out or indeed preventing the beneficiary of the bond from making the call. The short point is, though, that it's extremely difficult to achieve this, because in all jurisdictions, it's generally accepted that if you've entered into a contract to provide something which is on demand, then you should be held to that bargain. And in a UK context, or common law context, it really is often an issue relating to the delay or expiry of the bond, where often the beneficiary is looking to call it because they are concerned that there may be certain defects that the bond is supposed to cover, but it's coming up to the date of expiry, and rather than just let it expire and then be without the security, then the call is made, although sometimes that may be inappropriate. So I put there this question of duty to whom. I mean, obviously, normally the bank is the bank of the contractor who has been obliged to procure the bond. So there is often this tension within banks as to whether they really ought to be handing over money without inquiring with their customer. And of course, from the perspective of the person calling the bond, this is concerning, because what they're anticipating is that the bank should just pay over without any further question. So what we're talking about then is bringing an action, and in the common law context, it's invariably in the courts by way of an injunction to either compel payment or, more likely, to constrain payment by the bank. And quite often the bank will, consistent with its role as bank to the customer, will look to find some sort of way of dragging its feet, or looking to try and find some sort of condition within the bond. One point to make is that very often these on-demand bonds are very simple in their wording, so the opportunity for the bank to avoid payment, and indeed for the contractor to try and stop payment, is not going to be found in the bond itself. One area where in common law countries there is a willingness to perhaps investigate a bit further is to analyze the terms and conditions of the underlying contract, to actually see whether the bond is said to have been presented for a specific purpose, and whether or not there is some sort of underlying condition in the underlying contract. In my own experience, that happened to me in Sydney some years ago, where we thought we would be able to call on the basis of an on-demand bond, but the Australian court then looked at the underlying contract, and despite it being an on-demand bond, was prepared to challenge it on the basis of what was in the underlying contract. But generally speaking, courts will not step in, and obviously, if there is some evidence of fraud, well, that has always been a basis in the common law for a bond not to be, or for an injunction to be given by the court to prevent a call. If we go to the next slide, please. So in a common law context, the heavy law or black letter law behind this is that there really has to be a very strong case. There has to be an argument run that, by the party trying to stop the bond being called, that damages are not an adequate remedy. And obviously, if what you have is a bond which is a monetary thing, then clearly it is difficult to try and argue that damages would not be an adequate remedy. So in other words, the court will allow the bond to be called, and if subsequently it's proved that the bond should not have been called, then the damages are available to the contractor, and indeed maybe to the bank, for the fact that the beneficiary has called inappropriately. There is also this concept called the balance of convenience. There is certain law which does suggest that the balance of convenience is not really something which ought to be applied in the context of calling on bonds or injunctive relief in relation to bonds. But the balance of convenience is there to and can be established on the basis of preservation of the status quo. Indeed, that's something which has been raised against us recently, where a client did call on a bond, and the other side have said that the bond should not have been called, even though proceedings were ongoing, because calling the bond changed the status quo. But they were unsuccessful in relation to that. Next one was financial strength of the parties, a certain sort of imbalance, because quite often these bonds are significant sums, and it might be that the calling on the bond puts the contractor as the procurer of the bond in a very difficult financial position, so they're unable to continue with the proceedings, as an example. So that's a possible consideration. And then risk of irreparable harm was a similar sort of thing to the fact that the financial position may be tilted in some way if the bond is paid out. The duty on the party that is applying for an injunction is of full and frank disclosure. It's a little bit like an insurance contract, where there is this duty to reveal to the court everything that is relevant, because usually these proceedings for the purposes of getting the injunction are what's called ex parte, which means that the other side don't know that they're taking place and aren't present in front of the judge. And that then means that the judge is wholly reliant upon the information presented to him by the party applying for the injunction. And that's also related to this cross undertaking as to damages, which is that if you are there and you present information which allows you then to call on the bond, but in fact the injunction is sorry, not to obtain the injunction, but it's subsequently overturned, and there may have been some damages to the party who was unable to claim on the bond, then you are obliged to pay them in respect of all of their damages that have been incurred. I mean, I'll give you an example, and it's a reported case I was involved in where a client of mine was very, very keen to prevent a bond being called during a particular financial year, and they were happy to throw money at it. We were successful in obtaining the injunction, but that injunction was subsequently overturned, and then there was a heavy payment in damages that had to be made to the other side. But from my client's point of view, it was money well spent because they had delayed the call on the bond into the next financial year. So I'll stop on that basis. I've set out a little bit more law underneath in respect of some of the considerations that the common law or English courts in particular would take into account. But then just to hand over to Khaled then to deal with performance bonds in the context of Kuwait. Yeah, just to say that certainly from a common law perspective, it is difficult to achieve, but not impossible. Khaled.
Thank you so much, Andrew. Can we have the next slide, please? Yes, thank you. Well, first of all, maybe I should give an introduction of myself. I'm Khaled Youssef. I'm a senior associate at the litigation practice in the Kuwait office. I'm also a dual qualified lawyer. I'm qualified in England and Wales and in Egypt. Well, thank you, Andrew, for this introduction and for giving this brief about performance bonds. And also maybe I should give at the beginning or explain why performance bonds were one of the topics that we chose to talk about today. Construction projects in Kuwait are a lot, and this is obvious, of course, and we've recently seen in many cases that clients come to us from whether contractors or subcontractors with the fear that, or after being threatened that their bonds, the bonds that they have issued, are being threatened to be called by either the employer or by the main contractor if it's the case of a subcontractor. So we've seen this a lot, and the first question that they come up with is, can we stop them from doing that? So bonds, performance bonds are regulated in the Kuwaiti law, in the law of commerce, and they are described as unconditional and payable upon demand. And the Article 385 of the Law of Commerce says that the bank may not reject the liquidation due to reasons related to either or reasons related to the issuer and the beneficiary, or the bank and the issuer. So it's quite explicit in the Law of Commerce that it's a very unlikely matter that a bond can be stopped from being liquidated or being called. And also the bank would not put itself in such a risk of not liquidating or honoring the request of the beneficiary. So when the clients come and ask about this, the first thing that we say that it's not possible that the bank, or it's not actually likely, it's very unlikely that the bank would not honor the request. The second thing they ask is, can we resort to the court then? Because if the bank will not put itself in such risk, can we go to the court and get some sort of an injunction in order to stop the bank from liquidating the bond? As we said in Article 385, and based on that article, we've not seen it that the court would issue such an injunction to liquidate. It's very also unlikely that the court would step in to order the bank to stop the liquidation for many reasons. First of all, usually this happens, or this issue arises when the works are not completed. Usually the work is still in progress. So the court would not put itself in a position where it would stop the liquidation and while it's not still sure that the works were completed or not. Especially that injunctions in the Kuwaiti law, or the legal test, if you can put it that way, or the criteria for issuing injunctions in the Kuwaiti law, are not as particular or specific as in the English law, as Andrew just explained. For example, we have the legal test in the English law is the balance of convenience, for example, the risk of unreparable harm, and also whether there is a strong case or not. In the Kuwaiti law, it's quite different because it's quite generic, and it's subject to a very wide discretion of the judge. That's why the judge, there is no certain or specific criteria that the judge needs to be looking into according to the law. Maybe based on case law, previous case law, maybe we can derive such criteria. However, in the statutory law, there is no actually quite specific legal test like that. That's why we have not seen it that the court would stop liquidation or would step in by issuing an injunction to order a bank to stop liquidation. However, what we advise in this regard, since it's unlikely that the bank would from its side or from its end would not liquidate or would not honor the request for the liquidation or calling the bond, and also from the court, that the court is very unlikely to issue an order or an injunction to stop the liquidation. So what we advise is that what people would do, but this is something in practice we see, that the parties or the issuer could agree with the bank for maybe a period, like for example, they usually agree on a period before liquidation of the bond, during which the bank has to inform the issuer of the liquidation. So sometimes it's either a week, sometimes 2 weeks, or maybe up to 30 days. So maybe this period would allow resorting to the court to try to get such an injunction, even though it's highly unlikely, but at least we would have some time in order to resort to the court to try to get an injunction, because we would have some time, because the issuer would know that the bank is about to liquidate the bond. That's why agreeing on such period, on a good period, maybe would allow us, because the bank usually would not liquidate unless this period is lapses. Also, the thing is, if the bank does not honor this period or does not give us notice as agreed on our agreement with the bank, this could give scope also for a breach of contract. The same applies when it comes to unjustified liquidation by the beneficiary or the contractor or the employer, depending on the case. So for example, even though I've just explained that it's the bond will most likely be liquidated, either because the bank will honor or the court will not issue an injunction, if we agree in the contract, I mean in the construction contract, on certain conditions, and it's very well considered and well written and drafted, the conditions for liquidating the bond. This could also give scope for a claim for breach of contract later on, if it can be proved that the liquidation was unjustified. That's why it's very important to well consider and well draft this in the agreement itself. Next slide, please. Andrew, I think, yes.
Coming back to me in relation.
Yes.
Okay, so actually, could you just no, leave on stay on that slide. So the next session next section is in relation to limitations on liability and liquidated damages. Obviously, irrespective of the legal system that you're dealing with, a contract will give a remedy of damages to some extent. And this is what we're looking to do in this next section, is to compare and contrast what you would normally get in a common law context and what you may be able to get in a Kuwaiti context. And the reason for looking at it in a common law context is because many of the construction contracts that are used, like the FIDIC suite that is set out on that slide there, deal with damages in a way which is very typical for a common law contract or common law remedies. And the first one I just want to mention is this question of indemnities. The word indemnity is used in the FIDIC suite, but it actually means something very, very specific in a common law context. And I've set it out there. It's actually a wider base for claiming costs and losses than you would get if you were claiming purely contractual damages for a breach of contract. So it's something to look out for. And indeed, that word indemnity appears throughout the FIDIC suite, and we'll come on to it in the context of that last clause I referred to there, 17.6. But then, yes, I've made the distinction that in common law countries, although it often gets slightly confused, damages will comprise both costs, namely something that you find yourself having to pay out, and losses, something which you are unable to obtain. For example, loss on a contract or loss of profit. So costs and losses. And then the final thing I'll mention on that slide is of course, the often discussed issue of liquidated damages. And I'll go into a little bit more detail of what that actually means. So next slide, please. So very briefly, and I won't stay on this for too long, the basic principle of contractual damages in common law is this very old case called Hadley and Baxendale, which is really where it's a question of things which naturally arise from the breach, and those which would have been in the contemplation of the parties. So in English law, there actually isn't really any statement about what is a consequential damage. It's really on those two limbs. Does the damage that has been incurred, whether it's a cost or a loss, fall under either of those two? And I suppose it might mean that you could see that what's commonly called a consequential loss might fall under either. And that is what was dealt with in this case called McCain, and indeed also in the hotel services, Hilton International. Because what it emphasizes is, certainly in a common law context, is that it's inappropriate to refer to consequential loss or damage. It's appropriate to actually spell out in detail what sort of damage it is that you're saying you're not going to be liable for. The example in Hilton Hotel is always quite a useful one, I think, just in simple terms, where the contractor had installed the fridges, the minibars in a Hilton hotel, and they didn't work. And Hilton lost out in terms of all of the sales that they thought that they would have been making for the overpriced drinks and other snacks and what have you that were in the minibars. The contractor relied upon a clause which he thought was going to protect him for a loss of profit claim. But the court came back and said, well, no, on the limbs of Hadley and Baxendale, if you, what this was not a consequential loss, it was a direct loss on the first limb of Hadley and Baxendale. Liquidated damages then are often in two categories, certainly in a FIDIC contract, one for delay and the other for performance. Both are seen as being a reasonable bargain between the parties, that instead of actually having to, from the employer's point of view, instead of the employer having to prove his loss, he pays for that benefit of not having to prove his loss by being able to recover a set amount. From the contractor's point of view, he is not then going to be liable for any more than the liquidated damages, so that's a benefit to him. And the burden that or the payment that he has to make for that is that he can't challenge the liquidated damages on the basis that the employer may not have actually suffered any loss. So the common law sees this, the concept of liquidated damages as very much a sort of commercial deal that's done that will usually be enforced such that the employer, if he suffers more loss, can't overturn it. I just mentioned a concept of irrecoverable damages in a very famous case, which is to do with construction, to do with the swimming pool, where simply you can't, and I think this is reflected in some of the GCC codes, which is if the actual damage that is, in this case it was costs to repair, are disproportionate to actually satisfy the requirements, then the court won't, or the law won't uphold that. This was a case to do with the swimming pool, where the swimming pool was built and it was a little bit more shallow than it should have been. What the court said was, well, the employer can have some damages in this case, but they're not going to be the full cost of digging out the swimming pool and putting it into the correct depth. Next slide, please. So I've touched upon the concept of liquidated damages, and there is this sort of trade-off, as I've said, and the typical position in relation to common law liquidated damages is that it should not, that the figure that is claimable should not be a penalty and should be a genuine pre-estimate of loss. And this is often a big debate between lawyers and indeed contractors and employers about whether there has been any effort made to establish what is the genuine pre-estimate of loss. The fact is that really, as long as there's been some sort of even rudimentary attempt to come up with a figure, then that's usually going to be enforceable. Of course, in practice, what often happens is that assessment is made, and it's discovered that to put that figure in the liquidated damages would put off at most contractors from taking part in the tendering process. So very often the genuine pre-estimate is set or is established initially, and then it's reduced down. So more often than not, certainly in my experience for 30 years, the liquidated damages figure is less than the actual damages which the employer is going to actually incur. So consequently, the real benefit, and I repeat what I've said before, is that the employer is in the position where it doesn't have to prove whatever its losses are, damages are, but it may well be that those damages are greater than the liquidated damages fee. Next slide, please. However, there have been two little changes, or two very important changes that need to be addressed in relation to liquidated damages in a common law position, in a common law contract. The first is that the genuine pre-estimate of loss can now, on the basis of this case called Cavendish Square, potentially include some of the inconvenience that an employer may be put to for the fact that the contractor has been in breach of contract. This related to, I don't know how often it really happens in the GCC, but certainly in Europe, where if you park illegally somewhere, then a private company might say that there's a certain fee that has to be paid if your car's towed away and you want it to be released from the compound. Well, clearly, the damages in a direct sense that have been incurred by the employer in such circumstances aren't properly reflected in the let's call it the penalty that has to be paid. But what the court said was, well, you know what, you shouldn't be parking where you are. Yes, there isn't this sort of definite correlation between the amount of the penalty and the damage that's been suffered, but it is a fair thing for the employer, or in this case the car park owner, to put into its liquidated damages a measure of the let's call it the hassle factor, of some, indeed a sort of incentive to dissuade people from parking illegally. So the rule on penalties is slightly less distinct these days in the common law context, or certainly in an English context. And then the other point is just in this triple point technology, which is very important for contractors and employers to understand. This case went through various courts, where the courts changed their minds as it went through the appeal process, where what it was saying was that contractual liquidated damages for delay, the usual position was that if you terminated a contractor's contract, then he was in delay when you terminated him, you would be able to claim the liquidated damages up to the time of termination. And then subsequently, you would be able to claim general damages or unliquidated damages for the time subsequent to the termination. This triple point discussed these issues many, many times. And at one point, it seemed as if you've terminated a contract, then the liquidated damages provision is discarded in its entirety, which was a serious change from the law. But anyway, it's now been appealed, and a decision has been made, which brings us back to the original position, which is that the liquidated damages will apply up to the date of termination. I suppose in a GCC context, what that really emphasizes is you really do need to pay attention to the terminology of your and the mechanics of your liquidated damages provision, to make absolutely certain that it is going to be a remedy either as an employer or as a contractor in the circumstances that you are actually anticipating. On that basis, next slide, please. I hand back to Khaled. Oh, you're on mute, Khaled.
I'm sorry. Yes. Thank you, Andrew. I'll actually continue on that last sentence, very important sentence that you said regarding that liquidated damages clause in the agreement, especially that we see in most cases that it is based on common law concepts, which are quite different than the civil laws concepts, and here may come the issue. So talking about contractual damages in Kuwait in general, if they are not agreed upon in the contract, the court will estimate the damages. And damages usually comprise, or according to the civil law, comprise the losses incurred by that party and the loss of profit as well. Also, there is another condition that this damage must be a natural consequence of the breach, which is actually quite similar, as you said, Andrew, to the case of or the principle of Hadley and Baxendale, where that the damage should be a natural consequence, and by that it means, or according to the civil law, it could have been circumvented by the creditor through reasonable efforts. Otherwise, it may not be deemed as a natural consequence. Also, another similarity here to that case is the fact that the damages or sorry, the damage should have been contemplated at the time of the conclusion of the contract. The same also applies in the civil law. Otherwise, which also raises the issue of the consequential, consequential damages, as you said, Andrew, whether there is such a notion or not in the under the English law. But the same applies in the civil law. It also has to be contemplated at the time of the conclusion. Exception to that is in cases of fraud or gross negligence or misconduct. In such case, the damages could actually be extended to cover whatever losses arising out of that breach. Then we can move on to discharge of liability, whether the parties can agree to be discharged of the liability in advance or not. Generally speaking, according to the civil law, yes, it can be agreed upon. However, there is only also one exception. Again, it is the fraud or gross misconduct. But this takes us to the issue of the liquidated damages, when damages are agreed upon in the contract. Next slide, please. Thank you. So parties may agree to a predetermined amount as damages in case of breach. But something that we need to know here in the civil law especially, and that some parties, when they agree or when they have a liquidated damage clause, they think that this will not be subject to review by the court, or this will exclude the court's discretion, or or having the right to review the damages or that clause. In fact, and in practice, and according to the law, this is not true. The court will always have the right to review, but subject to conditions, of course. And any clauses, it is also worth mentioning here that any clauses excluding the court's ability or right to review the liquidated damages are to be deemed invalid. For example, liquidated damages can be reduced by the court on one condition, or subject to one condition, that if it can be proved that the damage is not as or is not has not reached the extent claimed by the party claiming claiming the liquidated damage. In such case, if the damage is not such or exorbitant damage, then the court can actually reduce the liquidated damage. The same applies also in the other case, if the damages can be increased by the court. But this is very limited. These in cases also of fraud or gross misconduct. In such case, the court can actually increase. But the test here is very hard to prove. And we say that, technically speaking, it might, I mean, it is in the law, and in theory it is applicable. However, in practice, it's not as easy as it may sound. Also, limitation of liability and capping, we find a lot of, or in many construction contracts, that limitation of liability clauses and capping the recoverable damage. How would that be perceived by the courts in Kuwait? Usually when it is capped, for example, usually we see it as a 10% of the contract price, for example. Usually this also is deemed as a liquidated damage clause. Even if there is no explicit liquidated damages, this could be deemed as a liquidated damage clause in the contract. And hence, it will be subject also to review by the court, subject to the conditions that I just explained, whether with regard to reduction of the damages or increase of the damages. Next slide, please. Then moving on to a very important also scope of liability here in construction matters that are usually some parts of actually or aspects thereof are usually misunderstood, which is the decennial liability for the defects or demolition of the construction. According to the civil law in Kuwait, the contractor and the engineer are liable for any defects that appear in the construction or any demolition, whether total or partial demolition. and that liability extends for 10 years. However, the misconception comes here in this regard with regard to the period. Usually it is misinterpreted into being a statute of limitation, that it can only, if within the 10 years a defect appears or there is a demolition, a claim for liability of the contractor on the engineer can be filed. However, this is not the case. The courts in Kuwait have always interpreted this decennial liability as it's a guarantee period, within which if any defect appear, then this will give rise, or this will be the incident which gives rise to the claim. And after that, the statute of limitation starts, which is the 3 years. So for example, if we have a defect that appeared on the last year, on the 10th year of the guarantee period, and then the defect was not known to the employer until after a year. So that means that the 10-year has lapsed. The 3 years statute of limitation would not actually start, would only start from the date of the knowledge of by the employer of that defect, despite the lapse of the 10-year period, the 10-year guarantee period. So that's why it's very important to differentiate here between the guarantee period, as explained by the court, and the statute of limitation. Also, it is very important in the construction agreement, which is obvious, of course, to well draft the obligations of each party and to the extent thereof. Why? Because depending on that, the liability for defects and demolition will be decided, because they can either, the contractor and the engineer and the consultant as well, can all be jointly liable depending on their obligations and the contract. For example, as you can see here, because it's mentioned the consultant registered at the municipality. If the consultant registered, because usually when we have construction projects in Kuwait, the parties working on that project are registered, have to be registered at the municipality, including the consultant who is supervising the works. So if if a defect appears in the works, and there was a consultant at the time of the works being performed who did not who did not point out or see that the reason for the defect, they would be liable. Also, there is another issue that arises, that sometimes the consultants get changed during the construction project period. For example, there was one consultant at the beginning, and halfway through they changed him. So it's very important also to regulate this matter in the contract, so that in order to, for example, if a defect appears in the construction, we need to, it's important to know how to decide or to attribute the defect to which phase of the construction progress and project, and also under which supervision was it. That period of the construction works. Was it the first consultant or the second consultant? And if the first consultant continues to be registered at the municipality, it could be likely that that consultant, even though he has left the site and he is not working anymore, but because sometimes they forget to deregister themselves from the municipality as well. So it's very important to do that, and it's very important also to specify the obligations of each of those three parties and the extent thereof, and what their works according to the agreement. And so, because again, that raises the issue of the decennial liability, as I said, and the fact that it is different also of the statute of limitation, the 3 years statute of limitation period. Next slide, please. Also, one thing, one actually important thing that I should say here, just before I give it back to you, Andrew, that liability for defects and demolition of the construction works may not be excluded according to the Kuwaiti law by any means. Back to you, Andrew.
Thank you, Khaled. So yeah, just to sort of finish up on this section in terms of the sort of substantive part of it, we just wanted to touch on this very, very important clause that you get in the FIDIC suite of contracts, and it appears in some form in virtually every international construction contract, and that is FIDIC clause 17.6. And I just wanted to highlight a couple of things, and then Khaled will step back just to say, just to sort of revise where we've got in relation to Kuwaiti law on this. So this is an absolutely key provision. It's applicable as a protection for both parties, but more often than not, it's very much a protection for the contractor. And it is absolutely key as a broad protection from both certain types of damages, and secondly, applying a cap to those overall damages. So you can see that the intention is to exclude things like loss of profit and loss of opportunity, or loss of any contract. But then the FIDIC wording does then use wording which it wouldn't really apply in an English context, which is the use of consequential loss. But what it has spelt out is some of the examples of the type of what we might call consequential loss. So that's very clear that it's excluded. A couple of other points to mention are, first of all, in connection with the contract. So the idea here is that if the employer wanted to try and bring a claim, for example, in relation to negligence, so not a contractual claim, then the contractor may be able to rely upon this clause to limit its liability in a negligence claim. The other important point is the list of exceptions to this type of damages. And one of them, and I go back to my comment relating to indemnities, invariably there is a separate section in the contract which lists out a series of indemnities, which are usually fairly standard, things like damage to third-party property or death or personal injury. And it's always important to make sure that those indemnities aren't added to in some way, because somebody just thinks, because of the language, that it's a right to claim, that you don't add to those indemnities, because one of the consequences will be that you the contractor, then don't get the protection of clause 17.6 and the type of damages, because the indemnities, the list of indemnities will expand, and you'll be exposed. Then the cap on liability is to be established as usually a percentage of the contract sum, or maybe the contract sum itself, but also be aware of what are the exceptions to that cap on liability. And again, indemnities raises its head. And then obviously the final point is that if there is any fraud, deliberate default, or reckless misconduct by the defaulting party, then the protections, both in terms of type of damage and the cap on liability, will not apply. One thing that I just wanted to point out there is that, and it came up in a UAE context not that long ago, was what if the employer has refused to pay when it ought to have paid, and then the contractor terminates the contract for what the contractor would say is a deliberate default, namely deliberately not paying what they should have paid. Does that then mean that the employer is unable to rely upon this clause to protect itself from claims that the contractor might make for loss of opportunity and other aspects, or indeed sums well in excess of the cap on liability that's been included? Anyway, that's just a brief review of that type of clause, specifically clause 17.6, and just hand back to Khaled to review a couple of the points from a Kuwaiti perspective.
Yes, thank you, Andrew. I mean, I kind of also touched based on these issues when we spoke about the liquidated damages, because capping that, first of all, that if let's discuss the amount. If we're talking about the amount and capping the amount, that would fall under the rules relating to liquidated damages. So the court will still have the right to review, as I said, based on different conditions, whether to reduce or to increase. So if it's capped, it still can be increased by the court if, as we said, there was a gross misconduct or fraud, which is exactly also the same as you said, Andrew. And in terms of the type of the loss, it could be limited under the general rule of limitation of liability, that a debtor may be discharged of liability, or his liability may be limited according to the law. However, this takes me back again to the senior liability, liability for defects or any demolition in the construction works, or any damage arising thereof, or loss arising out of that, may not be excluded by any means.
Okay, so next slide, please, just as a summary on this, and then I'll hand over to Omar on another aspect. So just the conclusions, and it's one that I'm always identifying, and that is, very often typical standard terms and conditions are used, and then somewhat at the last minute or without any great thought, there's a decision made on what is the governing law of the contract. Sometimes, even in the GCC, it may be English law. More often, it's going to be the local law. And it's very, very important when you're drafting contracts to pay attention to this, to understand that some of these clauses, which have been drafted with common law concepts in mind, simply may not operate in the way in which you're expecting, giving you the protections or remedies that either way that you anticipated, because of that decision to choose a particular governing law for your contract. So I then turn to the next slide, please, and just hand over to Omar in relation to an often arising issue in the Gulf, which is the subcontractors' rights in respect of making a direct claim. So over to you, Omar.
Thank you, Andrew. So regarding this subject, yes, it's important for any subcontractor or the contractor or the employer. They know that the subcontractor or subcontractor, they have fully right to sue the employer and the contractor himself without suing the subcontractor, which is you sign the contract between that subcontractor. For example, if we say that the employer and the contractor, they didn't pay for such subcontractor, and the subcontractor even them didn't pay for the subcontractor, so the subcontractor can have a fully right to sue the employer and the contractor directly. Even sometimes we face that the subcontractor and subcontractor governed the article for the jurisdiction and govern as Andrew mentioned just now, to be sure regarding the arbitration clause or the govern law or that. So here, what our advice to anyone that to make sure that the article of regarding the applicable law or the jurisdiction law, or if it's arbitration or as a local courts. So here, before you sign, please reach to any legal firm, not us even. So just to take legal advice in this regard, because it's very sensitive for the subcontractor and the contractor, the relationship between all these parties, and reflect that conditions. So here, that based on what shows in the slides, that 682 article, it's give fully right to sue the contractor employer, even if you don't have a direct contract with them. So even the article itself, it's mentioned that these debt or the due, it's considered as a priority debt, so you can enforce it before any normal creditor against that such company, even the workers. So the workers and the company itself as a subcontractor, they have the priority debt against the debtor or let's say the employer or the contractor. So this is what I would like to add generally. So I return back to Andrew.
Okay, thanks very much, Omar.
Welcome.
And then to sort of finish off, I'll hand over, next slide please, just hand over to Tom, which is sort of following on from what I was saying about enforcement or injunctions in the court and how might arbitration apply and the role of arbitration. So Tom, over to you.
Great, thanks very much, Andrew, and good afternoon, everyone. Thank you for joining us. I will be relatively brief. As Andrew alluded to, I'm going to take a slightly more procedural perspective on some of the issues that we've been discussing. If you look at arbitration, on one hand, arbitration offers a lot of advantages for resolving construction disputes. It gives parties the ability to select the decision maker, to select the arbitrator, look for someone who has the technical experience, the construction experience to make a strong decision in the case. It allows parties to use party-appointed experts for similar reasons. It offers things like confidentiality and other procedural protections, or if not protections, at least opportunities that you may not get in the court that are conducive to disputes that can be highly technical and factually driven. But there are some downsides or potential downsides to using arbitration to resolve construction disputes. One of those, as much as it hurts me to say this, is that arbitration can often become more costly than the parties anticipate. It can be more costly than court litigation in some circumstances. Another example, bringing the issue closer to those issues we're discussing today, is that given the nature of arbitration and the need to set up the arbitral tribunal, which can often take 30, 60, 90 days just to get the tribunal constituted, by its nature, arbitration is not particularly well suited for resolving disputes that require a decision on urgent interim relief at the outset of a case, which of course includes situations where one of the parties has made a request to liquidate a bond. Now, the rules of arbitral institutions have been changed in recent years to try to accommodate this situation. Many, in fact, I would say at this point, most of the procedural rules of the key international arbitral institutions now include provisions on emergency arbitrators. This is true of the ICC, the LCIA, the SIAC in Singapore, and recently here in Dubai, the new Dubai International Arbitration Center rules now have provisions on emergency arbitrators. Now, what is an emergency arbitrator? An emergency arbitrator is an arbitrator that is appointed on an interim basis in advance of the formal constitution of the main arbitral tribunal, and the emergency arbitrator is empowered to render interim relief. Now, the idea behind the use of an emergency arbitrator is speed. An emergency arbitrator, it varies from institution to institution, but typically an emergency arbitrator is appointed within 2 days of an application by a party to have one appointed, and must render a decision typically within, say, 15 days or so of receiving the file in the case. Now, despite this development in the procedure, there still are, I think, some limitations on emergency arbitrators. And I think that's particularly so when you're talking about the context of a request to liquidate a bond. As I've mentioned, this is still a relatively new phenomenon in international arbitration, and sort of the contours and the powers of emergency arbitrators are still being sort of tested and determined. But I think more importantly, there are still questions surrounding the enforceability of decisions rendered by an emergency arbitrator. Now, the form in which an emergency arbitrator can issue a decision will vary from institution to institution. At some institutions, and this is true with DIAC, an emergency arbitrator may only issue a decision in the form of an order. He or she may not issue an award. And an order, if the other party doesn't comply with it, will be inherently more difficult to enforce if you need to take it to the courts, where a party's not playing ball. So there are still some issues surrounding enforceability. There are also questions relating to, and this is true more broadly with arbitral tribunal per se, but issues relating to whether a performance bond or issues or disputes relating to a performance bond fall within the scope of the arbitration agreement. A lot of times the performance bonds will be viewed as a completely different financial instrument and therefore legal instrument. A lot of them may have their own governing law, their own dispute resolution clause. So there could be jurisdictional issues in relation to emergency arbitrators as well. There may be differences in the standards that an emergency arbitrator on one hand might apply to the question of whether an application to enjoin a request to liquidate a bond should be granted or not, and the standards applied by the courts. If you have, for example, an ICC arbitration seated in Singapore, where the governing law of the bond is English law, there may be different standards to be applied if it's an English court looking at the bond applying English law versus an emergency arbitrator who might be applying the law of the seat of arbitration or transnational legal principles or another body of law. And so to date, there really has been limited guidance on this relationship between emergency arbitrators and seeking interim relief through the courts. So it's still early days. I think it's important for parties to bear this option in mind. If they're confronted with one of these situations, it's important to know what tools are in the toolbox. There may be certain circumstances where you do want to go to the emergency arbitrator. You want to stay out of the courts for whatever reason, but there may be circumstances where the courts provide better opportunities for you. I do think it's important to bear in mind that by seeking interim relief from the courts, you will not, in probably 99.9% of cases, not be seen to be waiving your rights to hear the main dispute resolved through arbitration. So you need to look at what options are available and might be best for you. And I think with that, I'll stop there and turn the floor back over to Andrew. Thank you.
Yes, thanks very much, Tom. Very useful. So just to finish up, to draw those threads together, I think the message we're giving is this one of compare and contrast. Understand what it is that is the background to the contract drafting that you're having to deal with, which is very often going to be driven by common law. Be alert to the impact that a choice of governing law, Kuwait law, may have on those clauses. And then in terms of dispute resolution, spend a little time, I don't think we're saying spend a lot of time, but a little time on any sort of negotiation just to understand where you might stand in respect of issues that regarding enforceability, whether that's in front of the local courts or arbitration, and then specifically in relation to this aspect of the calling of bonds. Now we have had quite a few questions that have come in, but I am aware that we've run over time. So what we'll do is we'll answer those questions direct to the people who've asked the questions. But certainly, if any of you have any further questions that come to mind, either that have come to mind during this presentation or subsequently, please feel free to send them through to us. We will be doing a formal follow-up through our business development team. And with that, thank you very much for attending, and we look forward to your attendance at the other presentations and webinars that Altamimi will be running during the course of next year. Thanks very much. Goodbye.
Thank you.
Thank you, Andrew.